So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today I will be reacting to Indian labor laws. I enjoy this a whole lot, and this is specifically about hiring someone in India. I have a whole series on international comparative human resources. And so, what I'm going to go into is compare India with the United States, talk about the differences, talk about what is the case in both, and so forth. So this is from AZB Partners. They're a law firm out of India, and they wrote this. If you want to check out more about this, look at the link down below, and you can learn more about it. So to get us kicked off, there are no restrictions with respect to background checks, interestingly. However, what there is a restriction on is data privacy and the rules surrounding that. So electronic requirement or electronic personal data like passwords, financial information, physical, physiological, or mental health conditions, like that's HIPAA, but same with medical records and history, those are all covered under it, and you have to make sure that you're following these laws, right? But there is no concern with respect to actually doing the background check. As long as you're following the applicable data protection laws, you're all good in India. And that's really interesting. That's effectively the case in the United States, although we don't, particularly think about personal data, but that's a component, right? That's something that does exist. It's something that we have to consider when we are hiring someone. And so that's an interesting situation. It's an interesting caveat to put on it because it's really not that important in the United States, but otherwise, it is something that does exist. Similarly, there are no prohibitions against requiring a medical exam as a condition of employment. The only thing that's kind of interesting, and I just want to know why it exists. It says the HIV and AIDS Syndrome Act of 2017 prohibits conducting HIV tests without informed consent. Great, consent's good, consent's what we need. Why do you need, I imagine that anyone who's doing that would check. And all you could do is just force the person to do it, I imagine, and then they would just, if they didn't consent, they wouldn't get the job. Yeah, I think that's really interesting. But this is basically the same as the United States. It's advisable that employers undertake medical exams only in cases where there is a direct correlation between medical fitness of an employee and the work that is to be performed. Same thing in the United States. You want to connect the two. It's really critical. In addition, there's no prohibitions on testing of alcohol for drug or alcohol consumption. This is fairly similar to the United States. There are limits to it, surrounding specific drugs or surrounding specific states. Generally speaking, it's legal, but there are exceptions. And of course, you can put together laws in India that prohibit using drugs and alcohol during working hours. And so India is, again, very similar to the United States, not too difficult with respect to this, very interesting. There is, similarly, there is no requirement to give preference in hiring a specific set of people, which is pretty, basic. I do believe, and I don't know this for a fact, someone can leave a comment down below, but India is very state-based, meaning like there are a lot of local governments that have specific laws. This article specifically cites Haryana State Employment of Local Candidates Act, which means that you have to give preference to local candidates who are domiciled in the state of Haryana, which I don't know what. I guess unless they're remote workers, I'm curious what that means. And then they do have to, they are prohibited of discriminating on the basis of gender, disability, and HIV status, which, again, this is the second time HIV status has come up. That's very interesting. In the United States, you would consider HIV under disability. I firmly believe that for the most part. But it doesn't prohibit discrimination based on race, age, all the number of discrimination factors that can be done in the United States are not covered in India. So that's pretty interesting. Those specific ones, some states in the United States have a whole list of what, 10, 12 covered factors. And in fact, what's interesting is there are specific cities in the United States that prohibit caste-based discrimination, which predominantly affects people from India and I believe Bangladesh. And so as a result, there is actually more protections specifically in specific areas. I believe, if I recall correctly, like I think it's Seattle that has caste-based prohibitions, as well as maybe Berkeley. So it's just specific cities, but there is actually laws in the United States that prohibit caste-based discrimination, which predominantly affect people from India or ancestrally from India. There isn't a requirement for an employment written contract, but you should have one. And again, there isn't one in the United States, and frankly, most people aren't on a contract. Nurses and teachers might be, but generally speaking, it's a pretty rare thing. There is state-specific statutes that require it. So again, India does divert a lot to the states. There are more laws than just this, I assume, and those are predominantly focused again on the states and what's going on there. So keep in mind when we talk about this, we are talking national. I would love to speak to someone from India and get their perspective on HR in India, and we could panel up and talk about these things, and I think it would be a really useful exercise. So beyond that, we can talk about the probationary period. And again, just like the United States, there is no duration of a probationary period. It's defined by the contract or the standing orders applicable to the establishment. And usually they're structured such that they end before any statutory termination protections kick in, which makes sense. So what it's saying here is if there are rules if there are rules at the particular state where you work with respect to when you can fire someone, the probation ends before that time comes. And that's smart. That's exactly what you would want to do when that happens, but it doesn't appear to be required from law. As I've chronicled here, most post-colonial countries have a very significant and specific temporary agency staffing rules, and there's a lot of it. Again, I think it has something to do with colonialism. I don't know the specifics at all. I really don't, but that's my perception here. And there was an act in 1970 that governs the engagement of workers through third-party organizations or contractors, agency workers, and it applies to establishments in which there are 20 more workers engaged on any day in the preceding 12 months. And in that, they have to have a whole lot of registrations and licenses and ensure that the payment of wages and benefits to the contractors are timely and adequate. And I imagine that this was being abused during colonial times, and that's why it's structured this way, but I still find it very interesting. Well, that's it for Human Resources for the People today. Let me know about my reaction to India. What do you think? Are there things that I missed? Again, if an HR professional from India wants to panel up and speak to these things, let's talk about it. Let's dig into it, and I'll see you on the next video. Bye, guys.